Hello everyone. Before we dive deep into studies, it's highly recommended that you have a pen and notebook ready to take necessary notes for your learning journey. Please note that there may be a disparity between the visuals and the audio points. For an accurate interpretation, I would appreciate if you could prioritize the audio content only. Remember, if there's anything you don't understand, feel free to pause the video, rewind, and listen again carefully. This video, we will explore the sociological view of jurisprudence, arguing that law isn't static rules, but a living social instrument. Key thinkers like Holmes and Stone advocate that judges must be social activists, interpreting law by weighing rights against social justice and incorporating knowledge from social sciences, lawyers' extra version. This contents of the video is taken from the awesome book, Studies in Jurisprudence and Legal Theory, written by Professor Dr. N.V. Paranjape and published by the Central Law Agency. Here we go. The philosophical study of law, or jurisprudence, must fundamentally be an integrative and synthetic discipline, according to thinkers like Julius Stone, focusing on a purposive outcome, the attainment of humanistic justice achieved through the creation and application of humane and fair law. Stone encapsulated this revolutionary idea by famously defining jurisprudence as lawyers' extraversion, an assertion that implores the legal mind to look beyond the confines of dry legal texts and engage in an intensive examination of the principles and techniques of the law through the illuminating lens of present knowledge derived from disciplines other than law, namely the social sciences. This call for an outward-looking legal scholarship stems from the recognition that law exists not in a vacuum, but as a direct product and regulator of human society. Echoing this pragmatic sentiment, the influential American jurist Oliver Wendell Holmes Jr. viewed jurisprudence as possessing unlimited possibilities for adapting and developing law, a necessary function driven by the changing needs of human society and the relentless pace of the contemporary knowledge explosion. For Holmes, the traditional, narrow, and often blind obedience to the letter of the law, the so-called law in books, is inherently insufficient. It fails the primary purpose of a functioning legal system, which is to demonstrate a constant readiness for adaptation to new problems that confront society. He rejected the notion that law could be treated as a rigid, self-contained system, memorably stating, "The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if containing only the axioms and corollaries of a book of mathematics." To grasp the essence of law, one must understand not only what it has been, but critically, what it intends to become, requiring a constant, reflective consideration of history and existing theories of legislation. This transformative perspective, that law must be studied as an integral part of the entire field of social sciences, found widespread support among legal luminaries such as Sir Frederick Pollock, Brandeis, Cardozo, and Frank, all of whom urged the systematic study of law within its social context. The practical implication is that judges and lawyers who are well acquainted with the extra-legal aspects of the law, including its profound relationship with sociology, economics, psychology, and political theory, are uniquely positioned to interpret law in a genuinely purposive manner, thereby effectively distinguishing the theoretical law in books from the functional law in action. In this modern dispensation, a lawyer is no longer permitted to be a mere legal technician, proficient only in legal texts and procedure. Rather, they must embrace the role of a social activist, ensuring that the law serves to give healing touches to society and guaranteeing the robust implementation of the underlying policies that inform a particular legislation. This vital extra-legal version approach, transforming law into an instrument of social change and reforms, has been fully embraced by the highest levels of the Indian judiciary, finding favor with eminent Supreme Court judges, including Justice Gajendra Gadkar, Justice Y.V. Chandrachud, Justice Chagla, Justice P.N. Bhagwati, and particularly the eloquent Justice Krishna Iyer. This group of jurists consistently advocated for a pragmatic view to the application of law. Justice Y.V. Chandrachud, in the landmark case of Vishnu Agencies Private Limited versus Commercial Tax Officer, articulated this liberal judicial philosophy by observing that the legal fraternity should not construe the provisions of the Constitution in a narrow and pedantic sense, insisting instead that a broad and liberal spirit should inspire those whose duty it is to interpret law. he powerfully characterized the Constitution as a living and organic thing which, among all legal instruments, has the greatest claim to be construed. Ute res magis valit quam periet, a Latin maxim demanding that it be interpreted to have effect rather than perish. It is thus the solemn duty of lawyers and judges to actively extend the constitutional provisions for elimination of poverty, social inequalities, and economic injustices. This judicial philosophy necessitates a constant act of balancing, exemplified by Justice Gajendra Gadkar's disapproval of any rigid and mechanical approach to industrial law. He clarified that in constitutional disputes, the principle requires that fundamental rights are to be balances against the public good, while in industrial disputes, the employer's statutory right of freedom of contract must be balanced against the valid requirements of social justice, with the end goal being the creation of a reasonable adjustment in each case. The philosophy found its most passionate spokesperson in Justice Krishna Iyer, whose unique distinction lies in sensitizing the legal community to the imperative need for a pragmatic approach. He believed that the issues judges deal with are just copies of problems people have in real life, and that laws should only exist and matter if they are based on what society needs and are helpful to people. For him, law is intrinsically a pragmatic instrument of social order, and consequently, judges and lawyers can only fully discharge their respective roles when they have acquired sufficient knowledge, methodology, and interpretative skill in social sciences, the very source from which law derives its enduring strength and ultimate validity. The evolution of legal thought has led to various theoretical classifications, where legal philosophers have been categorized into different schools based on their core approach to law. However, it is crucial to recognize that such divisions are by no means comprehensive and exact. It is not uncommon for jurists to defy the strict bounds of one particular school, with the ideology of one school often overlapping with that of another, and some schools even representing a synthesis of two or more ideological thoughts. What remains certain is that these distinct schools reflect the socio-economic and political changes of a given time, thereby embodying a specific legal philosophy crafted to suit the needs of a transforming society. The traditional methodologies of legal theory are generally categorized according to the specific element of their subject they deem to be essential. Thus, the formalist theory is defined by its stress on the logical contents of judicial opinion. The utilitarian theory is characterized by its emphasis on the social consequences of a law, and the historicist theory regards judicial opinions as mere reflections of the circumstances in which they were written. The fundamental and shared problem with all such theories, as critically identified by Justice Holmes, is their inherent tendency to single out one particular aspect of the law as the essential aspect, resulting in a limited and often incomplete perspective. Consequently, it was Justice Holmes, acting as a profound legal philosopher, who denounced this limiting conception and powerfully held that the law has no single monolithic essential aspect, demanding instead that it be viewed holistically, reflecting its complex, living, and ever-adapting relationship with human society. This is the end of the video. Thanks for watching the whole video. If you enjoyed it, please comment in the comment section below. The learning is wow! Hit the like button, share it with your friends, and do subscribe to the YouTube channel Knowledge Drops 3.